Well, let's give it 1 more minute.
It's true that cultures can elements of self-preservation all the time. They don't have the switch and still celebrate today they wouldn't have this
So,
is an opportunity. The word helps rise to the top.
So whenever one.
great. All ready? Are we using microphones?
Yeah.
Well, good morning, everybody. Thank you for coming out. We are, we're here to talk about ISDS, of course, and I think specifically about the sort of fascinating political moment that we're in right now. And I left some copies of my book, Shadow Courts, out there, which is why I'm here moderating this. I'm a correspondent at Time Magazine, but I also wrote this book for Columbia Global Reports, and it's really kind of a primer on ISDS. It was published last September. And at the time, one of the reasons why I was attracted to this topic is precisely what we are talking about in this panel today, is that it is not just a liberal issue, and it is not just a conservative issue. It sort of is fascinating the way it cuts across these various ideological lines. And I was looking back this morning, and I noted that while it had yet to become a big news item, I don't think most Americans still today are going to recognize the acronym ISDS. But it's gotten much more important. And I said, one reason that ISDS does not follow the normal contours of the free trade debate is that you can be 100% in favor of free trade and still be against ISDS. Take libertarians, for example. And I sort of explained some of those positions. And then dyed-in-the-wool conservatives, a group that has also traditionally backed free trade, object to ISDS on different grounds. I sort of walk this through on page 17, 18, and 19, and it seems to me, I was coming into this topic in 2015, a little bit come lately too, but it's just struck me how I had heard these discussions coming from Elizabeth Warren supporters and Bernie Sanders supporters, but as soon as I dug into it just a little bit, it became this fascinating economic and constitutional issue as well. So that's what we're here to discuss today, and we're going to start first with Dan Dickinson, right? Oh, Lori Wallach, sorry. I'm unable to follow a very simple itinerary. So Lori's the director of the Public Citizens Global Trade. She's an internationally recognized expert on trade with decades of experience advocating in Congress and foreign parliaments, trade negotiations, courts, government agencies, the media, and in the streets. She's been closely tracking all the ISDS claims under NAFTA and other U.S. trade and investment agreements. She also sat down with me for about 2 hours and explained this topic to me from the ground up in 2015, so thank you.
Thank you very much. Thank you, everyone, for coming. So the diverse political views represented here today reflect the unusual consensus in this very polarized political moment against investor-state dispute settlement in general, and the sense it needs to come out of NAFTA in specific. And it also represents how isolated the corporate lobby is in its extremely strident defense of ISDS and opposition to the proposals put forward by the administration to roll back these extreme corporate rights. ISDS was only first ever included in the U.S. trade agreement during NAFTA. It was a radical experiment in using the brand free trade to implement a set of corporate privileges and literally a restructuring of power in the global economy that has no passing resemblance to the reduction of border taxes or opening of quotas that were the agenda of traditional free trade agreements. ISDS elevates individual companies to equal status with an entire sovereign nation state. It makes it less risky and expensive for firms to offshore jobs, and it empowers corporations to attack domestic policies by going to tribunals of 3 private arbitrators, frequently corporate lawyers, who can order unlimited sums of compensation to be paid by a country's taxpayers. In all 3 features, extraordinary, and we will make the case very strongly, a bad idea in this NAFTA experiment. So now, almost 25 years later, there have been just under NAFTA, almost $400 million in damages paid out under investor-state attacks against toxic bans, zoning rules, water regulations, timber policies, and an array of other policies for which compensation simply would not have been available under the domestic laws of any of the countries, but largely even under the domestic, very, very robust property protections of the United States. In the context of this broad consensus against ISDS, the corporate lobby is screaming in defense of it as if what was being attacked was something natural and normal versus a radical power grab that was inserted into these agreements thanks to there being a lot of corporate advisors at the table, a closed process, and no role for the public to actually shape the agreements. So the improbable consensus against ISDS shows how very isolated the corporate lobby is in trying to defend these special privileges. And even perversely, while the Chamber of Commerce, the National Association of Manufacturers, and others are on the warpath against the notion that they should be denied these outrageous privileges slipped into NAFTA, you even have the American Auto Policy Council in their testimony to the ITC on NAFTA renegotiation noting that ISDS was unnecessary and moreover dangerous to include in NAFTA because it was so controversial. Indeed, following the TPP debate, the issue has been elevated in public discourse. 400,000 signatures to a petition delivered to the administration a couple weeks ago about taking ISDS out of NAFTA. But well before that, there has been a broad consensus against. Before turning to our next speaker, I just want to review how broad, which is the National Conference of State Legislatures, representing the legislatures of the 50 states, Puerto Rico, and the other territories, have had a position against ISDS for a decade, through the entire period of Republican majority control of the legislatures. This was not a leftist thing. This was 50 state legislatures in consensus taking a position. The U.S. Association of Attorneys Generals of the states have had, NAG, have had a position starting warning against NAFTA at the time of the fast track debate that ISDS would be problematic. The National Association of Counties, the National League of Cities, they all have raised the severe threat to their regulatory policy space and to constitutional order and federalism of ISDS. Small business organizations, most recently last month, 2 of the major ones, sent out letters asking the administration to take ISDS out of NAFTA. Not just small business organizations, but unions. Yes, 2 groups that normally fight, united taking out ISDS from NAFTA. And stark criticism on ISDS has come from, in the legal front, none other than Supreme Court Justice Chief Roberts in a dissent, and the likes of Senator Elizabeth Warren, progressive former Harvard Law School professor, environmentalists, and think tanks like Cato that are on the more conservative side of the spectrum. Republican members of Congress recently in a letter to the administration saying take ISDS out of NAFTA, and for decades, Democrats, which is to say there is everyone saying let's get rid of ISDS, which is now joined by numerous countries exiting the system, including South Africa, Indonesia, India, followed by many of the following on the exit from many Latin American countries. And then, on the other hand, you have the corporate lobby. I will just end by sending people to the attention of a letter being released today by 230 law professors and economics professors, including a lot of professors who supported NAFTA in the first instance, not the least of which are some that worked very hard to pass it, like Secretary Reich of that era, the Labor Secretary under Clinton, who is now a professor at Stanford, as well as folks like Joe Stiglitz. This letter really lays out the breadth of intellectual opposition in academia to this regime, and I will simply draw folks to, in the news release, in your nifty and ISDS swag bag. By the way, that's from Public Citizen. No one else at this table takes association with that. We're the only ones who do gimmicks like pens and stickers. But in that bag, you'll see a news release that includes a quote from Joe Stiglitz about how ISDS promotes offshoring and subsidizes the wrong behavior. That is very similar to what you will find in this Fortune op-ed by Dan Eichenson, that is also in the bag. Forbes, sorry, not Fortune, Forbes. That is also not dissimilar from the piece you will see in the Washington Post from Joe Biden's former chief economist, Jared Bernstein, which is to say a broad consensus. Thank you very much.
Thanks, Laurie. Dan Eichenson is next. Dan is the director of the Cato Institute's Center for Trade Policy Studies. He oversees and conducts research on a diversity of issues related to international trade and investment policy. Eichenson has been consulting, analyzing, and writing about international trade issues since 1990 and has authored dozens of papers and a book on various aspects of trade policy, including U.S.-China trade relations, bilateral and multilateral trade agreements and institutions, and a lot of other information, a lot of other topics that intersect with ISDS. Dan.
Thank you, Haley. Thank you all for coming, and thank you for inviting me to this event. Do I get one of those bags? Good. Lori and I don't normally agree on a lot of issues related to trade and investment, but
Anything.
pretty much nothing. But I think we both have come to the conclusion that ISDS is a problem, that it should be purged from the NAFTA and probably other trade agreements. I think we probably arrived at that conclusion differently, taking different paths. I get questions often from media saying, why would somebody from Cato oppose investor protections? Isn't that bad for business? My response is we're not pro-business. We're not anti-business, but we're not pro-business. We're pro-market. And the ISDS provisions, I think, undermine the way the market is supposed to work. It means that I believe in clear rules. We shouldn't have policies in place that tilt the playing field in favor of one party over another. That's protectionism. It has many manifestations. ISDS gives advantages to particular types of companies over everybody else, and I think that's a good start, the first reason to be concerned about it. Let me just give you a little bit of background about how I get there. We support free trade, really free trade. A lot of people in Washington say they're for free trade, but they really mean that they're for opening foreign markets, but not necessarily our own. We're for free markets. Over the past 7 decades, trade has been liberalized. There's been a lot of tariff reduction. That's good. But protectionism lurks behind the borders too, and there's been this kind of effort to try to get at some of the regulatory rules, some of the laws, some of the provisions that are in place to protect societies, and so that we don't only get rid of barriers between borders, that we sort of homogenize the playing field. I support the idea that we should explore as far as we can where we can do that, but there's just some issues where you're just infringing on others' sovereignty, and I think some things need to be off limits. We have free trade agreements, so-called free trade agreements. They're not really free trade, they're managed trade. So they have some liberalization in them, but they also have baked-in protectionism, either very long tariff phase-out periods, exclusions, carve-outs, investor protections, and excessive protection of intellectual property. So the question is, should free traders oppose free trade agreements? And I would say not necessarily. Depends, if you want to make the perfect the enemy of the good. It depends. I will support trade agreements where there is, that are net liberalizing, where there's more trade liberalization than protection in them. To give you an example, my colleagues and I did an assessment of the TPP when it came out. And we looked at it, took us a long time, and we studied it chapter by chapter. And actually, we gave grades to 22 chapters, grades from 0 to 10, 0 being protectionist, 10 being most free trade. We didn't give any 0s, 1s, or 2s, and we didn't give any 9s or 10s. But of those 22, we found 15 to be net liberalizing, 15 of the chapters, 5 to be protectionist, and 2 to be neutral. The investment chapter, we gave a 6, so it was slightly above. And that's because there was a lot of liberalization that made it, that got rid of discrimination for investment, something called negative list approach. There was an effort to prevent sort of localization requirements and joint venture requirements. That's good, but the investment chapter included ISDS, which we have a big problem with. But for that, we probably would have given it an 8 or a 9. So the problem with ISDS, one needn't distrust business or dislike business to not be a fan of ISDS. It's anti-market, it creates negative externalities, which are basically costs borne by those who don't benefit from the policy. So I have several reasons why. I'm just going to go through the litany very briefly. First of all, investors don't need ISDS. All right? The world consists of governments that are competing for investment. Every government wants to attract investment. And if they expropriate, or if they don't give fair and equitable treatment, they're not going to get as much investment. So the notion that this is necessary to attract, to get investment into developing countries is incorrect. Investment is risky. Of course it's risky. Foreign investment is even riskier. But that doesn't mean that these companies who want to invest don't have the resources, aren't savvy enough to do the cost-benefit analysis. The rewards better be good enough to justify the risks that they're going to take. So what they're asking is that ISDS gives them, it's just an extra sort of subsidy to them. Lighthizer, USTR Robert Lighthizer the other day, last week, said, "It's always odd to me when the business people come around and say, oh, we just want our investments protected. I mean, don't we all? I would love to have my investments guaranteed, but unfortunately it doesn't work that way in the market." And I think he's right. ISDS socializes the risk of investment. So the companies are the ones who will benefit entirely from, reap all the rewards. But if these are part of a trade agreement, what might happen is that the other country might say, you know what, if we're going to give on ISDS, we're not going to open our markets as much. So that means that it's coming out of the hide of maybe U.S. exporters or U.S. workers. It could be the case that foreign companies who can avail themselves of ISDS in the United States, well, they have extra recourse relative to U.S. companies. U.S. companies have to go through the court system, domestic court system. They have a choice, one or the other. So citizens who want their government to function properly and don't want their regulations and laws challenged by other countries bear some of the cost. And taxpayers, if we have to pay compensation, also bear the cost. Those are many problems. Fourth, outsourcing subsidy. I mean, ISDS subsidizes outsourcing. Lori mentioned it. Outsourcing. We are competing with the world for investment. And investors think about skills of the workforce, size of the market, infrastructure, access to ports, regulatory environment, tax environment, rule of law. The United States has always been scored pretty well on that, so it's always a safe place to invest. So if an investor is thinking, I'm going to put this service center in the United States or in, Brazil, they might come to the conclusion, well, it's either one, not sure. Oh, wait a second, we have ISDS, so the rule of law benefit, that advantage that the U.S. has, is neutralized by ISDS. It's funny, the proponents of ISDS will say that ISDS helps develop and cultivate the rule of law abroad. I see it as thwarting it, because instead of reforming domestic judicial systems, they don't have to. Developing countries can just say, oh, well, all we care about is the investment, getting investment in here, and here they have alternative sources, so they don't need to develop these things. Just a couple more, and I'll stop. So ISDS also benefits risk-averse behavior. Now that doesn't sound too bad, but if you think about it in a market economy, you need risk-taking behavior. So company A might want to invest in Brazil. It might be risk-taking enough to say, we'll take a chance. Company B might say, well, it's a little bit too risky, we can't do that. If you have ISDS, company B is advantaged by that. So a risk-averse company, normally a larger incumbent company, is benefited, whereas the challenging company, a young company that might be willing to take more risks, which are necessary for market capitalism to work, has to take a back seat. So the other thing is the optics, and I think it's really important for trade liberalization. There is this myth out there, I call it a myth, maybe everybody here won't agree, that trade only benefits big corporations and the rich. Fact is, trade liberalization is good for smaller companies relative to bigger companies. Bigger companies can endure the higher costs. It's better for lower income Americans relative to wealthier Americans because they spend a higher proportion of their budgets on imported goods. But when you see ISDS, it makes it hard to refute that myth, which is something I try to do. I try to refute that myth. So I think if we got rid of ISDS, we would see more support for trade liberalization. Lighthizer said he wants support for NAFTA from the left and from the right. Getting rid of ISDS might help with that on the left. I'm not sure how much support would come just from getting rid of ISDS. Lori, I remember we had you at Cato a couple of years ago for a TTIP conference, and I asked you that question. Would you support TTIP if ISDS were out? And you said, well. So there are other things maybe, but I think it could help at the margins, and it's an effort to compromise. So I think we need to get rid of it. It only benefits a very small subset of the U.S. economy, and hopefully it'll happen, and there'll be enough support coming over from the left, and we will restore the pro-trade consensus. Thank you.
Thanks, Dan. I'm saving up questions for all of you. But now I'd like to introduce Bruce Fein. He's the chairman of the American Freedom Agenda, the founder of Bruce Fein and Associates, Inc., and the Litchfield Group, and he is the author of Constitutional Peril, The Life and Death Struggle for Our Constitution and Democracy. He's also a weekly columnist for the Washington Times and served as the Associate Deputy Attorney General in the Reagan administration.
Thank you, and I feel daunted here following two exquisite predecessors in their remarks, but I'll try to at least be as good as Cicero was to Demosthenes, who can claim to speak quite with the same eloquence. My focus is on the United States Constitution, and I want to address, I think, some fundamental misunderstandings or misperceptions, and some of them I think are displayed already. And that is, the Constitution doesn't depend upon popular opinion or how many people vote to support X, Y, or Z. If that were true, I'm sure most of our Bill of Rights would not be a law today. And so when we think about ISDS and its constitutional vulnerability under the Appointments Clause, it really shouldn't be formed by how many professors said X, Y, or Z. I mean, professors at one time said blacks had small brains than whites. They can get it wrong. Justice Robert Jackson said in the famous flag salute case that constitutional rights are not subject to public opinion or the outcome of any election. So we need to remember that. We can't be swayed by, well, some people like it, some don't, they want favorite corporations or not, because the issue basically was decided in 1787 when Article 2 of the Appointments Clause said that any official that exercises significant power under the laws of the United States has to be appointed by the President with the advice and consent of the Senate. And if you want to change that rule, then you have to amend the Constitution. And the reason for the rule is not mindless. It says if you have significant public policies under the U.S. laws, they ought to have politically accountable people who are implementing those laws. So in the process of self-government, we can hold those people accountable. The next election, they're appointed by the President. He's responsible as one of his subordinates or for his decisions in that way. I mean, it's an integral part of what we call self-government. That may sound, very highfalutin and unreal and unearthbound with regard to people. They want to make money. Hey, this is trade, and our economy's going to go higher or lower, and it will affect the outcome of the election. But our Constitution isn't about money. It's about liberty and process. It's about the dignity of self-government and following particular rules. Oftentimes I go over to the Chamber of Commerce and try to recite to them Sam Adams, who was kind of the leader, spiritual leader, if you will, of the American Revolution. And he exhorted that, ye who love wealth better than liberty, the tranquility of servitude better than the animating contest for freedom, Go home from us in peace. We ask not your counsel or your arms. Crouch down and lick the hand that feeds you. May your chains rest lightly upon you, and may posterity regret that you ever were our countrymen. So you talk about whether free trade is good or bad for the United States in terms of enhancing our wealth. It's kind of irrelevant to the constitutional provisions. If you don't like the constitutional provisions, you think they're inhibiting maximizing wealth because you don't care about philosophy or liberty, then you have to amend it. You don't get to decree it by popular opinion or otherwise on your own. And we have come to, I call it almost a self-lobotomization of our understanding of the Constitution, that it's not taught anymore, and it's not understood in the White House, certainly not today's White House, in the Senate, in the House. We're talking about the ISDS problem with, you have private individuals interpreting U.S. laws like Article 3 judges who get confirmed and in rendering judgments that are enforced in U.S. courts, and they're not accountable to anybody. And we subcontract out these authorizations. We subcontract out our war power to the United Nations. We subcontract out the treaty power through executive agreements. I mean, one of the elements here, think about this. In 1916, the United States actually resorted to a treaty in order to regulate migratory birds with Great Britain. A treaty requires a 2/3 vote in the Senate to ratify. Very, very high hurdle, because the framers were unified in their conviction that the executive branch would repeatedly sell out the United States on his own without any checks in order to aggrandize his power for pursuing some particular vendetta or to get some equivalent of the Pharaoh's pyramids. So they said, no, this is Alexander Hamilton, who in general was the most articulate defender of a muscular president. He said, we can never trust the president in developing or in negotiating international agreements. He didn't believe in the art of the deal, and he was there at the Constitutional Convention. Therefore, we must have the Senate ratify treaties. So if we have migratory bird treaties, and here we have NAFTA, whose importance to the country dwarfs migratory birds, and it's no treaty. Stunning. I think Bob Bork, I think Senator Byrd at the time was equally astonished that this would not be viewed as a treaty. I'm reminded, it's a similar problem arose with regard to the Iran agreement, which was an executive agreement. This is the nuclear issue. And Secretary of State then, John Kerry, was asked, why isn't this a treaty? All other arms control agreements had been treaties. And his response was, it's so hard to get treaties ratified. He supported a treaty for disability rights, and it got voted down, and he wasn't going to have anything more to do with the Senate. I said, oh, really? Because it's too hard. We're going to cancel elections because it's too hard to win and get voted? I mean, they're truly stunning statements made about the disrespect for procedural regularity. Because we need to remember that these provisions in the Constitution that relate to process, they are the equivalent of what Madison called a structural Bill of Rights. A structural Bill of Rights to protect the American people from tyranny, not to protect the vanity of the three branches and seeing their powers upheld. And that's why the Supreme Court has stated repeatedly, it's not a defense to a separation of powers violation that one branch eagerly has surrendered its power to another. That's irrelevant, because the beneficiary is the American people in the integrity of the process. And if you think the process is flawed, you amend the Constitution. You don't turn it into a homonym. So the words that they sound the same, but they mean something different because you've decided popular opinion has changed. Now the reason why maybe my voice is getting louder is because this is like an infectious disease. It is across the board. The war power, the treaty power, executive privilege, oversight power, the Constitution is irrelevant up there. And it's not just the White House, the whole society doesn't even talk about it. It's not in the presidential debates, it's not in the media, nothing. So we have a Constitution that's on life support. And the ISDS is just one symbol about it. Now why do we have it's unconstitutional? The president shouldn't be negotiating it to delete it. He should say it's unenforceable. No one's paying any attention to that. Is it acceptable for him to continue to adhere, even for 1 month or 1 day, to a provision in the that's unconstitutional in the NAFTA agreement? You should say, no, I'm out of here. It's invalid. He takes an oath to support and defend the Constitution. He's not bound by what a previous president did. He didn't negotiate the original treaty. The Constitution still is the Constitution today. So that's where we are, in my judgment, on the ISDS. I don't really care about all these arguments, it's pro or anti-corporation or makes us wealthy or not, because that really isn't part of the discussion of its constitutionality. The constitutionality turns on, does this respond to the intent of the framers in insisting that we go through a politically accountable process before we entrust the interpretation and execution of laws of the United States to any particular official? The answer is it's wrong-headed. If you like the general idea, then make the officials who adjudicate these NAFTA disputes subject to the Appointments Clause. There you got it. Moreover, why would, since the United States in general, although it's becoming less so, is the gold standard of due process, where even though we have grave deficiencies post 9/11, that compared to other countries, it's still a model. The other country doesn't want to entrust to our trappings of due process that exceed anything that's in NAFTA. It's too bad. Then they can go elsewhere for their adjudications, but at least for us, we stick to our Constitution. And the fact that we would even have this debate speaks volumes about the marginalization of the Constitution in our political culture and in the fashioning of our laws and treaties.
Thank you, Bruce. Our last panelist is coming in via Skype. Jeffrey Sachs is,
Maybe just wait.
okay.
There he is. Okay.
Hi, Jeffrey Sachs is a university professor and director of the Center for Sustainable Development at Columbia University, as well as special advisor to the UN Secretary General on the Sustainable Development Goals. He's a best-selling author and a syndicated columnist. Thanks for being with us today.
Great. Can you see me?
Yes.
Yes.
Can I see you possibly?
We'll work if we can turn around that camera.
Good.
There you go.
Great. Hi, everybody.
Hi.
Hi. I think I have a small cameo appearance today. I know you're having an active but detailed discussion, and I was asked to join briefly as one of the signatories of a letter sent by 230 academics, mainly law professors and trade specialists and economists to President Trump, calling for the removal of ISDS from NAFTA. And I'm a strong supporter of that proposition and a proud signatory to this letter. This is a follow-up to a letter that was sent last year on a similar theme, but with regard to TPP and TTIP, where, again, there's a very broad and very interesting consensus across the political spectrum, really from the free market right to the pretty anti-trade interventionist left. It's a quite wide spectrum that